I now would like to ask Steve Romalewski to give us a presentation on how the maps have changed, and hoping that the technology is working, of course.
Thank you, Jeff. Thank you very much for the opportunity to speak and to share our information. So my team at the City University of New York's Graduate Center, the Center for Urban Research, led by John Mollenkopf, we were very involved in mapping information around the 2020 census. And the next logical step in that was to map the first use of how that census data was used through redistricting. And so just a quick overview, we developed, following on the points Dr. Service made about transparency and the importance of involving people outside the kind of smaller circle of political insiders. We named our project Redistricting and You, because redistricting affects everyone, and everyone should be at least aware of the redistricting process. These are just some quotes in support of the mapping work that we did, and our website made it easy, we think, for people to, during the redistricting process, understand how districts might change, so you could see how it would impact you and your communities around you. And then now that the maps are final, presumably, you can see how they changed and what your new district looks like. So what I wanted to do is go through two examples, hopefully we have time for both, about how the districts changed that highlight a number of points that have been raised so far, and in very interesting ways. So this is District 10. That was drawn by a special master of the federal court and was in effect from 2012 to 2022. And you can see it goes all the way from Manhattan's Upper West Side, across New York Harbor, down into Brooklyn, and combines more or less the communities of the Upper West Side and Borough Park in Brooklyn. When the state legislature changed that, their plan that was ruled unconstitutional, the lines or the boundaries in Manhattan were similar, but you can see that it kind of contorts itself to go around in order to continue to connect Borough Park in Brooklyn with the Upper West Side of Manhattan. And you might think, well, just like what some people say about good art, that they can't really explain what it is, but they know it when they see it. You might think, well, this is obviously a gerrymandered district. And maybe it is, but in terms of the partisan gerrymandering, it actually has more connection with the district next to it, District 11, which we'll talk about in a moment. And then the Special Masters District, Dr. Service, I can call it his district, I think that's okay, dramatically changed how the outlines would be, continued to connect Manhattan with Brooklyn, and actually made it much more compact, obviously, and actually made it a little bit more Democratic leaning than in terms of the presidential vote share in 2020 than the earlier proposal and the earlier map. And then the map that we have now for these 2024 elections, and then will be in effect starting in January 2025, was very similar. You could see just some slight changes along the eastern border. So one thing that I think is very interesting about this is following on what Dr. Service talked about regarding the communities of interest concept, which is becoming much more important in how districts are drawn and what it means for people living in these districts, is that when the New York Independent Redistricting Commission held their hearings on the district lines, people from the Upper West Side and in Borough Park testified that that the district should not be changed because those two communities should be considered together as a community of interest, largely because of religious and cultural characteristics, which is one way, of course, to view communities of interest, even though those two communities are in different boroughs, miles apart. When you look at the voting patterns, so this is the 2020 vote share by precinct, blue is Democratic, red is Republican, you can see that those two communities are kind of diametrically opposed. Upper West Side, overwhelmingly Democratic, Borough Park, overwhelmingly Republican. And so it I think highlights how tricky it is, and communities of interest, while very important in some ways, are in the eye of the beholder and can be defined in many different ways. The legislature's plan kept those two communities together, so they respected the interests of the residents that made their points. But you can see that what the change in District 10 did was enable District 11, which is predominantly on Staten Island. Staten Island as a borough doesn't have enough population to support one district under the population equality rule, so it has to extend beyond Staten Island into Brooklyn. And you can see that by contorting District 10 all the way around Park Slope, it enabled District 11 to include all of Park Slope and nearby communities, which are overwhelmingly Democratic, and that would have flipped District 11 based on the 2010 presidential vote share from Republican to Democratic. And that was one of the reasons, or what factored into the court's decision to declare that an unconstitutional partisan gerrymander, the legislature's plan overall. Interestingly, the plan that we have, the district that we have now, basically splits Borough Park in half. And so while the district is more compact and it doesn't have the kind of convoluted nature of what the legislature proposed, it does, bisect an obvious community of interest. And, district lines have to be drawn and communities, may get split up. But I think that's, it's interesting to keep in mind, and in the context of making sure that the voters and people who have to live with these districts, not just the politicians who in some ways come and go, but people who live in these districts have to, they're going to deal with the consequences. And so now the residents of Borough Park have to reach out to two congressional representatives when they want to make their case in Washington. So I thought that was kind of an interesting result from how we, went through the process. So I hopefully have a minute or two to talk about another example, talking about upstate New York. So upstate is a little more complex because the apportionment decision after the 2020 census said that New York lost a congressional district. Upstate New York lost population. Downstate New York, by and large, gained population. So the district that New York State lost basically came out of upstate. And so the district changes across upstate were much more involved, much more pronounced. So this is one example. There are many, many examples and interesting stories throughout all of the districts. And again, this is just Congress, not including the Assembly or the Senate. So this extended all the way from New York's southern tier up to Lake Ontario, predominantly Republican district. When the legislature changed it, they changed it much more substantially, much more compact. And then the special master's plan kind of moved it northeast a bit, also compact. One interesting thing about this plan is that this appears at first glance to include 3 whole counties, which is one of the important characteristics of trying to redistrict, that you don't split up political areas or administrative areas. So this includes Onondaga, Madison, and Oneida counties. But if we had the chance to zoom in, we would see that the village of Cleveland in Oswego County is included in this district. The line cuts across Lake Oneida and includes just a few hundred people, a couple of census blocks in that village. So it's actually a 4-county district, which means that people in Oswego County, they also now have to reach out, or they would have, sorry, if this was finalized, they would have had to coordinate their lobbying efforts, their advocacy efforts with 2 congressional representatives. Not the end of the world, but it has actual consequences when you're trying to make the case for improving your community through legislative action. And then the final district, as Dr. Service points out, definitely includes more county splits in this area and elsewhere. And when you look at again, one lens of looking at how these districts change and what their implications are. So this is looking at the 2020 presidential vote share by precinct across the state. This is the prior district line. This is how it would have changed if the legislative plan took effect. And you can see that they really pull in and include in one district the predominantly Democratic centers of Ithaca and Syracuse. And then the special master's plan is a bit more mixed. And then the final plan is where we are now. And we'll see if we went back to the other slides, I think the current partisan makeup based on the 2020 presidential results and 2022 gubernatorial results is a bit mixed. So we'll see what happens as the congressional representatives flip from one party to another going ahead with elections in this district. But again, I think a really important aspect of this is not so much the partisan impacts, but as Dr. Service points out, what this means for people living in these districts. And we always really made the point whenever we would talk to the media about what these maps show is really to get those stories told, because again, people have to live with the consequences of the new lines probably for a longer time than many elected representatives who will come and go. So this is our team, and I wanted to thank you very much. Maybe we'll have opportunity later for Q&A. I'm happy to talk with people afterwards too. Thank you.
Thank you. Okay, before we bring up the first panel, just to remind those of you who are attorneys that might have come late, that CLE credit is available, but to receive CLE credit, you're going to need to sign in either downstairs or if you didn't do that here, outside this room. And then also, importantly, to sign out before you leave the building so that we can account for and give you the CLE credits. This also goes for those of you who are panelists and who are attorneys. You also get credit for being panelists today. I like it also, we have food available at both sides of the room, and I'm told that there'll be, I think, hummus and pita bread adding to the menu sometime closer to 11 o'clock. We are not, however, serving lunch. So I'd like to bring up our first panel. That includes Ken Jenkins, Congressman John Faso, Ben Weinberg, Esmeralda Simmons, and Cesar Ruiz. Their biographies are in the packets you can link to. Unfortunately, Jerry Vadamala from the Asian American Defense Fund cannot be with us. He fell ill yesterday and is not able to join us this morning. So for the first panel, which I will moderate, I'd like to take a look at what's happened since the last cycle, the 2014 constitutional amendment, the post-2020 process, the work of the commission, the role the courts played, and where things ended up with the maps that are being used in next week's primaries. So first, we're going to have Ken Jenkins, who is the current chair of the State Independent Redistricting Commission, talk to us about his role as the chair of the committee and the involvement to successfully send to the legislature maps for the assembly and congressional districts. I'm asking each panelist to take not more than 10 minutes so we can stay on time, and then we'll see if there's room available for Q&A afterwards. Okay.
Well, first, thanks, Jeff. And it's certainly a privilege to be with all of you here this morning. My name's Ken Jenkins. I am the chair of the Independent Redistricting Commission. I would want to first make sure to recognize some of my colleagues that are here. Commissioner Yovan Collado is here as well. He's actually getting CLE credit now, now that he has passed the bar. All right, so congratulations to him. Sid Parker, who was our data person, is here as well, and Karen Blatt, the executive director from the Democratic side of the Independent Redistricting Commission, and want to talk through some of that as well. Let me take a step back first just to go forward. David Imamura, legislator Imamura now, David Imamura was the chair of the Independent Redistricting Commission. I came in between, so now that I'm out of the witness protection program, right? Because yes, I am out there in the witness protection program. Dr. Service, it's been a really fun challenge to go through all of this. At every one of the, we had two different court cases that we had to deal with, right? That was help inform us on the way that we operated after the initial 2014 amendments. And at every one of our 12 public hearings that I was conducting on the assembly side, when we had to go, we got the chance to start from scratch, in essence, I said, how many times in life do you get an opportunity to have a do-over? In 2014, we had amendments that were created, and the citizens of the state of New York decided that they wanted to have an independent redistricting commission, put this process together, made sure that process had public input on multiple occasions. David Imamura and the commissioners at the time did a great job of going through above and beyond, trying to get as much public input as possible. The commissioners did the best job that they could do, presenting cases, and then we had court cases that followed that. But it was the first time through the process. And no matter what anyone would like to say, as a person that's been involved in government in different opportunities along the way, anytime you have a process that starts, there's going to be bumps in the road. There's going to be modifications, and there may be need for change. The question at the end, which I'll do a minute on at the end, is what kind of things that the commissioners are working on right now. We have our meeting, for those of you that follow us, on Thursday. I don't remember the time, Karen, up in Albany. I think it's got to be 11 a.m., right? It can't be 10, because I wouldn't make it up by that time. It's 12. Okay, so 12. Thank you, Karen. 12 on Thursday, where we're going to deal with our budget issue, one, and then move forward with trying to set a process for us to get together and have some comments that we might want to make to the legislature, which obviously they won't take a look at until the next session. We had some challenges, and David had some challenges through this, and the commissioners at the time, both Yovan and myself, were not on the commission at that time. We should start with, there has been a special master's congressional map used in New York State since 1983. The last four congressional maps were drawn by a special master, 3 of them at least that were out of state special masters, which was a knock on our special master, no knock on Dr. Service. So people need to understand that. And it's a challenge because we live in a world, we get a lot of information, a lot of data, and the media, as was pointed out, was suggesting that we had all this gerrymandered. The last 4 maps were done by special masters. There was not a gerrymandered map. There may be differences in that. So the districts between the east side and the west side of Manhattan, as a born and bred Bronx guy, right? The reality is that we understand that the east and the west side are different. That doesn't mean that the map that was created had a problem. It just means that that's how we grew up. So again, we have to go through that process. 2020, we had something that happened, March 3rd for us in Westchester County, called COVID. COVID-19, the pandemic severely disrupted the operations. All the staff was working remotely. We had to set up a physical office. That was very difficult to do. Global supply chain issues caused us delays in getting necessary equipment, computers, et cetera, that hampered our ability to start the ball moving. The redistricting data itself, the census was behind. The Census Bureau Data Office released the data on August 12th, 2021, which was past the expected date of March 31st, 21, and that obviously severely impacted the timeline for redistricting, compressing the schedule, increasing the pressure on the team to meet the deadlines. And it should be noted that even though there were delays in the release of data, the constitutional deadlines were not changed and had to be met. From a funding perspective, the Independent Redistricting Commission did not receive funding until June of 2021. Despite the appointment of commissioners, co-executive directors in 2020, during this particular period, commissioners were unpaid, thank you, David, and lacked a budget for travel, and were constrained in initial operations and outreach efforts. The census itself, the numbers were likely impacted by COVID as well. In New York State, all of us know we were expected to lose 2 seats. We ended up losing 1. And the fact is, while no matter how much people complain about the census process, we actually over-reported is what it was told. So we may have actually lost 2, but the reality is we lost 1, and that had to be modifications that were done. There was a greater reliance on online responses. That shift benefited areas with good internet access and digital literacy, but posed challenges for those with limited access to technology. Those groups were typically harder to count, and such as non-English speakers, renters, and people living in crowded living conditions, and those were disproportionately affected by the pandemic's disruptions. We all understand that from a independent redistricting commission that we can always have better communication, always. There's always room for improvement when it comes to communications with the public. We received a lot of public testimony, but not all of it was relevant on what we needed to hear. Perhaps next time we could work with the agencies that are involved, some of them that are sitting on this great panel with us, to do a better job of understanding and working with those existing network, tapping into those resources, et cetera. The staff did go out to those folks that invited us to come out and speak with them into communities, but that is not always enough. The commission can build upon the foundation laid by the organizations and maintain community engagement throughout the redistricting process and avoid the duplication of efforts. By pooling resources and coordinating activities, the commission and partner organizations can maximize the impact of outreach efforts and ensure a cohesive and a unified message in communities of interest. In 2023, we're going to add in a new classification for MENA. That's the Middle Eastern, Northern Africa, and that's going to make some changes, and that's one of the reasons why, from our perspective on the Independent Redistricting Commission, the commissioners feel strongly that the commission needs to continue with staffing and be able to take the data as we move along and to be able to make those modifications and be prepared so we can have a much better process. It doesn't necessarily mean that everyone's going to be happy with the outcome. That's why I'm still in witness protection, right? But the reality is that we have to continue to do things. When we looked at the maps, and we had public testimony, people, as was noted, came out and testified for what they wanted and what they advocated for, the communities of interest. And that is a really big, important part for all of us listening through this process. In part of the maps that were created by Special Master Dr. Service was for the Chinatown in that Manhattan area, where our friends from APA continued to come to us and say, hey, we lost our input. We lost some of our strength by the way things were modified. It doesn't mean it was a bad thing, but it means that we have to always continue to work and listen to the communities to try to make modifications in that. And what we tried to do through this process is listen to those comments. I think we had some ridiculous number of email comments that came in. They were mostly for District 16 that you pointed out, Dr. Service, right? And that they wanted specific things to happen in the district. We didn't make any modifications in the map that we presented. I think at the end of the day, people looked around and they thought that we were going to do some things differently because of the political world and the polarization that we have in our country as a whole. And what we tried to do on the Independent Redistricting Commission, although we were split, 5 Democrats and 5 Republicans, that we all worked really hard to make sure that we stayed true to the independent redistricting process, which was the 2014 amendments that came from the people of the state of New York that said to us, we need you all to have consensus and compromise. And yes, some people would like to see the district, and I've read some things along the way that maybe there should be an odd number of people on the commission so that there's not deadlock. Well, there's not deadlock when you're able to do the work and work through that. And our court processes helped inform and shape those things that were not very clear in the law itself. And we were able to both times have, for the assembly lines that we adopted and for the congressional lines, a 9-to-1 vote. And surprisingly enough, the first time around was a Republican, and the second time around was a Democrat. So that means from a process perspective, to be able to have these things going through and listened to and taking the work and listening to individuals and making the modifications that are necessary and presenting new information out, we were able to accomplish that in that period of time. The last thing I want to mention, again, is where I started. It's a brand new process. And yes, it was 2014 when it was adopted. 2020 was the first time around through that. And if there's not changes that we may or could suggest, that would be an unthinkable kind of consequence. There's nothing perfect. Dr. Service said that his maps aren't perfect. I know our maps weren't perfect. And guess what? At the end of the day, the legislatures finally adopted his maps were not perfect. But we tried to do the very best that we can to balance things out. I live in a county, and I understand that sometimes when we split counties up, there were questions on why things were done or not done. The difference between the assembly lines and the state legislative lines, so the Assembly and Senate, is that you have a difference that you can have up to 5% difference in population. In congressional districts, you don't have that. It's one person, one vote, period. That means somebody's block, somebody's community, someone's neighborhood, someone's community group, some county, some town, village, hamlet, et cetera, is gonna get split up. We just want to hear as many things from people as possible and make those changes. And I'm really happy that we have the opportunity to go through this process for me and for Charlie Nesbitt, who is my vice chair. And we worked really hard together with all of our colleagues. Every one of those commissioners put in blood, sweat, and tears to be able to do that. We certainly lost our good friend, John Flateau. And we really missed the work that he helped do for us. But he, by the way, was the guy that did the lawsuit in 1983, which was the last time we had a legislative adopted back. So with that, thanks a lot, Dr. Weiss.
Hey, thank you very much. Okay, our next speaker is an old friend and colleague of mine, Congressman John Faso, who represented a district in the Hudson Valley. John and I used to work together in Washington, I'll say 40 years ago, when I represented the state assembly and John the state senate. He's since moved to Albany and had a career in Albany and Washington. And it's my pleasure to welcome him here today.
Thank you, Jeff. Really a pleasure to be here, and thank you to New York Law School and to Jeff Weiss for all the work that you have done over the years on redistricting and trying to keep the public informed as to this process. Jeff is right. We knew each other, worked together a little over 40 years ago. We both started at 10 years old. Just in case there was a question, sometimes child labor laws don't apply in the political context. But I want to give you a little overview, and mine is a Republican perspective on this process, having gone through the redistricting in 1992 and still bearing the wounds from that process, and having worked to organize and to represent the plaintiffs in the Harkenrider case. And also, I particularly liked what Dr. Service said about winning plaintiffs should be able to recover their fees, because I was one of the people responsible for raising the money to pay for this that we had to fight the state of New York over. And I can tell you, it was well into the 7 figures. And the first number in those 7 figures wasn't one, in terms of the legal fees and the expert costs that are involved in challenging a gerrymander. So the overriding goal of that 2014 constitutional amendment was to limit the power of the state legislature over redistricting, and specifically the amendment had two main goals. One, creating the IRC, as Ken mentioned, and he did a great job along with Charlie Nesbitt in terms of recovering this process after the Hoffman case. But creating the IRC with the exclusive process for redistricting, with a voting system that sought to ensure and require a bipartisan product. And the second overriding goal was to eliminate partisan gerrymandering with a strict prohibition against the creation of districts to advantage one party or candidate over another. The Harkenrider v. Hochul case was a landmark decision in our state, fully upholding the specific language of the 2014 amendment and sending a message to the legislature that its unfettered control over redistricting was now limited by the terms of that amendment. The Hoffman v. IRC case was a distinct step backwards, in my opinion, which irrationally determined that Harkenrider did not impose a plan for the full 10-year period over the decade. But even so, Hoffman did not undermine the basic findings of Harkenrider, that the amendment set forth the exclusive process for redistricting and that partisan gerrymandering would be rejected by the courts. As we all know, this process didn't go as they contemplated by the 2014 amendment. Blame for this, I can tell you, rests almost exclusively at the feet of the majorities in the state legislature. Since attaining supermajorities of the legislature in 2019, and I spent 16 years in the unique purgatory of being in the minority in the state assembly in Albany, Democrats consistently attempted to undermine the purpose and intent of the 2014 amendment governing redistricting. And let me outline the ways in which they did this. First, as Ken had mentioned, they refused to fund the commission, making a startup operations impossible. Despite a clear command of the Constitution, they did not provide adequate funding, or any funding for that matter, to the IRC. It took a lawsuit brought by the Government Justice Center, which I was involved in that as well, in 2021 to force the legislature to provide the IRC its funding. They sought a new constitutional amendment in 2021, which would have undermined the bipartisan nature of the IRC. That amendment would have eliminated the bipartisan appointments to lead the IRC staff, resulting in no meaningful minority party involvement in the IRC operations. The amendment would have also eliminated the two-thirds voting majority requirement to approve a redistricting plan to the legislature with a simple majority vote. It would also have created an escape hatch for the legislature to adopt its own plan if, for whatever reason, the IRC never sent a map to the legislature. And of course, as we know, and I was involved in this campaign as well, the voters rejected the 2021 amendment with 56% opposed. After the voters rejected the 2021 amendment, the legislature sent to the governor a bill which they passed in June of that year and sent it to the governor in November after the voters voted down the amendment. They sent a bill which would have allowed the legislature to adopt its own plan if the IRC never sent a plan to the legislature. One suspects that this was their plan all along. That legislation attempted to amend a constitutional provision with a statute, which, as any first-year law student can tell you, is not kosher. And the Harkenrider decision ruled that this legislation was indeed invalid as an attempt to amend the constitutional provision with a statute. In fact, the entire effort of the Democratic majority and Governor Hochul was to undermine the IRC and its very independence right from the get-go. Again, the purpose of that 2014 amendment was to reduce the power of the legislature over redistricting. Democrats in the legislature have spent the past 5 years systematically attempting to thwart the will of the people as expressed in 2014 and in their 2021 rejection of the amendment. It is now obvious that every Democratic effort since 2019 was to undermine the IRC and its bipartisan process. We should view skeptically any new reform ideas coming from the legislature which are not bipartisan in nature. Both Harkenrider and Hoffman decisions have emphasized that the legislature must vote on the IRC plan if it rejects the IRC plan, it must use such plan as the basis for any subsequent plan it adopts. Such subsequent plan is also constrained by the statutory limitation of no more than a 2% change of the population of any district. Both Harkenreiter and Hoffman cite the 2% rule as an essential part of any new legislatively adopted plan. Yet, when the legislature adopted its congressional map in 2022, it cynically overrode the 2% rule. Even when the legislature adopted a revised map after Hoffman, the legislature still did not follow the 2% rule. The final congressional map adopted by the legislature closely followed, as Dr. Service said, it's 94% his plan. And I think that's good, because his plan created more competitive congressional districts in New York State than any other state in the nation. We have 8 or 9 legitimately competitive districts. And frankly, gerrymandering has there's no partisan virtue on either side. Republicans do it where they can control, and Democrats do it where they can control. Look at Illinois. Look at other states on the Democratic side, Colorado, New Mexico. They did it, and Republicans have done it in Florida and Texas and North Carolina. And so there's no virtue on either side. That's what makes our constitutional provision so unique. It's an explicit constitutional protection against partisan gerrymandering. So where do we go from here? There should be no substantive changes to the 2014 amendment, in my view. The IRC in 2032 and in 2031, and I will not be involved, I promised my wife, I will not be involved in redistricting in 2032. 30 years of this is enough, frankly. The IRC in 2031 should work to ensure that a bipartisan plan is adopted for submission to the legislature. They came together after Hoffman, which Ken alluded to, and he was great in this process, and they sent a revised congressional plan to the legislature with a 9-to-1 bipartisan vote. There's no reason to think that that can't happen again. The voting procedures and appointments should also not be changed. Adoption of a tiebreaker will only mean that a partisan majority in the legislature will have the ability to enact a partisan plan, as was done in New Jersey in 2022. Calls for a tiebreaker or changing voting procedures will eliminate the bipartisan process and once again restore one-sided redistricting authority to the legislature. Finally, both Harkenreiter and Hoffman should act as a warning to future legislatures that they must strictly follow the procedures set forth in the amendment and resist partisan gerrymanders as likely to be thwarted by the courts. If future legislatures understand that failure to follow constitutional procedures will surely mean the imposition of a judicial remedy, they will act more responsibly. They didn't think that would happen in 2022. They thought they had unfettered ability to do what they wanted, and we proved in Harkenreiter that the courts would stop them. As the League of Women Voters said when they supported our position in Harkenreiter in their amicus brief, they quoted Dr. Samuel Johnson. When a man knows he is to be hanged in a fortnight, it concentrates his mind wonderfully. Well, when the legislature contemplates a future gerrymander, Harkenreiter and Hoffman precedents should act to concentrate their collective minds as well. Thank you so much.
Okay, well, thank you. Okay, so we've heard about the 2014 amendment, we've heard about the commission process, and we know that we think the maps are in place for the rest of the decade, but there was about a 2-3 year period of intensive litigation in several state courts involving the congressional state assembly maps over a period of time. So I've asked Esmeralda Simmons, who is a veteran of I'd say 5 decades of redistricting, to take a look at and review all the litigation that took place. I heard Esmeralda give this presentation a while ago and thought that if somebody could put all the different cases together and the back and forth and the ups and downs of them, that she's the one to do it. So Esmeralda, tell us what happened.
Well, I think John has done a pretty good job of that. From one perspective, for those of you who do not know me, I am a voting rights attorney who has specialized in protecting the rights of Black New Yorkers, particularly in New York City. And as Jeff has said, this is my 5th decade. My husband doesn't believe me when I said I won't do it again. But if I'm alive, I hope that there will be other folks who will be doing it with me. That's what happened. What really happened. And this is something that folks need to pay attention to. Really, there was a complete river change in New York State this round. Before that, we were being guided by the New York State Constitution with its, don't count, don't cut this, don't do this, don't go over a valley, don't go in the stream, and the Voting Rights Act, specifically Section 5 of the Voting Rights Act, which was in effect. So folks like myself and now Justice Paul Wooten and the late John Flateau would run into court every redistricting and stop discriminatory maps from being upheld and force them to draw better maps. I'm talking about the state legislature to draw better maps. There was no independent commission. Come 2014, with the creation of the constitutional amendment, it shifted not only what the criteria was going to be and how it was going to happen away from the state legislature, which I was very happy about, but I was not happy with the commission at all. And it came with all of my predictions, like any old hag in this history, in this business, came true. When I was recently out of law school, I had one of my jobs was to do legislation, and I was told, like any good New York law student I didn't go to New York law, but I know they do the best things here too. Never create a commission that's even numbered. Never, ever do it. You're creating havoc. So while I would love to see the ideal nirvana, where we all get along, I have never seen that in New York State. I've never seen it in the legislature. I've never seen it in other commissions. And I think we should go by what the old rules were. Well, let's talk about these litigations. Thanks, John, for clarifying where Hockenrider came from, because that was a mystery to some folks, particularly why Steuben County. Well, so what? In case you didn't know, it was brought before. It was brought in the Supreme Court of Steuben County, a lovely place, very, very difficult to get to from New York City, and from other parts of the state. The judge that received it, presumably by the wheel, was Judge Patrick McAllister, and he did his best. I have to tell you, he did his best to wield a very unwieldy situation where, when redistricting cases are circuses. You have a dozen attorneys over here, a dozen attorneys, everybody wants to intervene, everybody wants to be involved, and then the judge is supposed to sift through what is the truth and what is necessary in the law. Not only was there ridiculous time restrictions at hand, and you have to realize that this was get a legitimate map so we can have an election in 2022, and we're already in 2022. And they expect the map that was already passed, the map that I call it the Jump To map from the state legislature. Why did I call it the Jump To map? I'm glad somebody understands it. Because when the initial redistricting commission sent a letter saying that they could not come up with a map, rather the legislature jumped to it immediately and had a map. Wow. How interesting.
They had it in the
Instead of reading the state constitution and maybe saying, no, you got to go back and come up with a map. So, don't jump to it, folks. But understand that the court in Hockenrider did what it had to do to enforce the state constitution. There is such a thing in New York State as elected officials thinking that they are the law, and that the law, and since they write the law, they figure they are the law, and they ignore the law. And they just do whatever they want to do and hope nobody sues. Hope you heard that.
Mm-hmm.
And hope nobody sues. Because if you don't sue, it sticks. It sticks. Well, this time they got a big awakening. And I'm not quite sure that they have gotten slapped around enough. You gotta hear it. Did you hear that even though there's supposed to be a 2%, they went to 8? Nobody's challenged it. I am not suggesting that anybody should challenge it. I am really quite tired of litigation over the congressional lines. But let's be honest with you. Unless somebody is watching, and I really mean watching, and and lawyers are not the ones that need to be watching, by the way. Please don't mistake this. The real rulers here are the techies. They're the ones that tell us when the rules have been broken. We can't know unless they tell us, oh, by the way, there's a deviation over here. By the way, look at where they crossed the line over here. So they're the ones that tell us. And if you don't get funded properly, you're not going to have the right level of expertise to tell you that. So it all ties in. I'm going to continue. Strange things happened in Hockenmeyer, according to how things usually work in New York State. Immediately, there was a Court of Appeals. I'm sorry. As soon as the judge made his decision, there was an immediate appeal. There were some people, and I know, I sat with him and said, please. It's going to the Court of Appeals. You know what happens when things go to the Court of Appeals? Whoever the ruling party is wins. Guess what? Didn't happen. Instead, the then Chief Judge, Janice DeFiora, with a 4-3 majority, struck down the legislators' got it map and said, no, this has to go back. But here's where the question mark came. Usually, they say it has to go back through the process. No, this court said it has to go back to the court to draw a map. Why? I cannot tell you why. That's not the normal way it happens. So they sent this map, they sent the mapping responsibility back to the court. The court hired our expert, I'm calling you ours. Good job, by the way. Our court hired this poor guy out of Pennsylvania to whip up a map that was supposed to pass constitutional. Well, when I say constitutional, I mean New York State constitutional and federal constitutional and the Voting Rights Act. Because the folks that were looking like me, is this in compliance with Section 2 of the Voting Rights Act? It was done. And an election was held on time. All right, they changed the petitioning for 2 days. Who cares? The election was held. Nobody was happy. No one was happy. I'm putting aside the political folks. I'm not talking about the good government groups. Nobody was happy because nobody got what they wanted, which was something that was going to affect the governance of this entire United States of America. Who is going to rule the Senate? Who is going to rule in Congress? That's what people are looking at, which means that the rights of individual voters and the rights of groups of voters, Blacks, Latino, Asian, people who are covered by the voting rights, sort of gets thrown in the water because people are looking at this big picture about who's going to control Congress, who's going to control the U.S. Senate. But just like the Republicans did with the help of our wonderful panelists here, some folks, I have yet to hear where it came from, decided they were going to reopen. I'm saying reopen. It's not a reopening. And all of you, not all. All right, you heard of stare decisis, right? Okay, so how does this happen? A group of Democrats go into court, not Steuben County. Instead, they go to Albany court. Oh, Albany, how interesting. State capital. And what do? They say, we want you to compel the Independent Redistricting Commission to do their job. And if I had been the judge, I would have said, what are you talking about? This is done. There's a court decision. We have maps. Those maps are good. What are you talking about? Compel them to do what? They don't have anything left to do. Well, that's what the judge said. Peter Lynch said, no, sorry, Dems. I can't go along with your reasoning. But in the interim, there was a change in the Court of Appeals. Too many people didn't like that judge, that chief judge. Too many people didn't like, and she decided that she would find peace in Long Island and away from the Court of Appeals.
Yeah.
And now there's a new Chief Justice, Roland Wilson. Well, no surprise. When the case gets to the Court of Appeals, which is almost immediately, because now we're in a time crunch again, that court decides that, oh no, the IRC has to make the decision. And this is the part I liked about that decision. Because I had been saying, why the hell does somebody mandamus IRC? You know, this is it said, you are ordered IRC to do X, Y, Z. You're ordered to do it by this. You're ordered to do it by that. And I started spreading rumors of contempt. If you don't do it, IRC, guess what the court's going to do to you? So the people on the IRC would hopefully feel some fire under them to get things done. So even though we know that with the current chair, he can pull off kumbaya moments, I thought the idea of possibly being held in contempt by the Court of Appeals might have had a little to do with it. Anyway, the case went back to the IRC. It's a soap opera. The case went back to the IRC, and it goes on and on and on. Goes back to the IRC. There are no hearings, but they did not they. The fractured Democratic part of the IRC invited comments, not the whole IRC. And there were comments that were sent in. And relying upon the hearings that were the 10 hearings, they did a good job the first time around. The 10 hearings that were held on the first round, they came up with a map that they agreed to 9-1. And I'm leaving out the assembly. I'm leaving out the assembly because I wasn't supposed to talk about the assembly, okay? Anyway, they come up with a map, and now everyone's holding their breath. Is this map going to stick, or is it not going to stick? The map goes through the legislature, goes to the state. They send the one unified map to the state legislature. The state legislature says, "Oh, I got something," and pulled out another map. Yeah, hey, well, people don't change their stripes, all right? Now understand, they're acting the same way legislatures act. I'm not making them bad people. This is what people in power do. They conserve their power. What happened after that? No challenge to the state map. Nobody has challenged it. I'm saying it quietly. It's in effect. I thought there was going to be a challenge. On voting rights grounds. Nobody challenged it. And with the 9-1, and I'm sorry, I'm losing my place here, okay. So the good news is that on February 27th, the legislature produced maps. The only thing it changed was moving the petitioning back a little bit. So you've already seen the maps comparison. It's a really good exercise. And I thank Steve for that, because you don't usually get to see them laid out. First map, second map, third map. So you could really see the major differences, or in this case, the lack of differences. And where all the arguments are, where all the hysteria is about. And I, for one, also have not really honored East-West, by the way, in prior redistricting. There have been thus far no appeals. I hope there are no appeals. We need a little stability. Why? Because we have other work to do in New York. And that is, in my opinion, we need to fix this system. We need to have a really independent commission. This commission is not independent. It's appointed by the legislature. As somebody who has been a legislative appointee to many a board, I'll tell you, they try to make decisions for you. And people who want to listen to them will listen to them. And these folks, they're getting paid. So there's even more at risk. Usually I'm on the non-paid boards, okay? And I'm going to end there. I do want you to know that all of the parties involved all the parties, both the initial IRC, the IRC when there was a change in leadership and change in some of the commissioners decided they'd had enough. Everybody worked very, very hard. Very, very hard. I cannot understand how the special master got that job done, but he did. Fantastic work. And I want you to know that the courts and their staff, who are supposedly supposed to review all of this in like 24 days, or it's ridiculous, folks. So mistakes have been made, but we have maps that most people are happy with. I hope that we get to see those maps remain because, as I said, we have much, in my opinion, much more significant work to do in terms of creating a real independent system in New York State. And I thank you for your attention.
Well, thank you, Esmeralda. Maybe the temporary ending to the story is that the legislature this year passed Chapter 91 of the laws of 2024 that limits challenges to redistricting plans
That's right.
to 4 different jurisdictions: Erie County, Albany County, Westchester County, and New York County, meaning that they're not going
No,
back
Albany.
to Albany, and not going back to Steuben County anymore. That's where things stand now. So let's take a look now at what was intended, the 2014 amendment.
Legislative shopping.
Yeah, to the structure of the commission. What was the hope, the goal of the reform effort going back to 2012, 2014, and where do we stand today in light of that? So I've asked Ben Weinberg from Citizens Union to talk about that. He'll be followed by Cesar Ruiz from Latino Justice PearlDef, the shop that actually litigated the first case that our friend, the late John Flateau, brought in 1982, my first involvement. We are running up a little short on time, but please try to work within the time limits if you could. Ben, please.
Thank you. And I first want to thank you, Jeff, for getting us all together and organizing this event. You know, as I was preparing for today, I read your article kind of laying out how the last several years unfolded. And I must say, when it's laid out with such clarity and kind of every lawsuit neatly leads to the next one, it almost seemed like it wasn't that bad.
Oh, God.
So I'm glad we had Ms. Simmons here to remind us it was a mess and
Torturous.
and torturous mess. Yeah, but I'm here, I suppose, to represent the viewpoint of good government groups and Citizens Union related to the 2014 amendment. I should say I serve as Director of Public Policy with Citizens Union, and CU, as well as others in the space, many of them here, has been working on and advocating for redistricting reform for decades and decades before 2014 at both the state and city levels. And, you know, a lot was mentioned here about control of Congress and the national implications of these decisions, but we're a city-based group, so we don't care much about what happens outside of New York. Our interest is really in limiting the political influence over map making in New York. So just to remind us, where were we before 2014 or 2012, I should say, really, because it started in 2012? Population deviation. So that was allowed up to 10%, which means every cycle we had tens of thousands of people kind of shifted from one district to another. New York City was deliberately either overpopulated or underpopulated to benefit either the majority in each house, I should say, with no set rules on how to draw maps, not many set rules, I should say. Very creative map making divided neighborhoods and communities and counties and cities. And that's why if you at that time would have overlaid congressional, Senate, and Assembly maps one on top of the other, they just made no sense. And just to remind us that also people's homes used to be redistricted out or in specific districts to protect incumbents. I was looking at some of our older materials and was reminded that one of the clearest examples of that time was the young candidate Hakeem Jeffries, who was drawn out of his Prospect Heights district after he mounted and kind of almost successful challenge to an long-term assembly incumbent. So redistricting was conducted above all else to benefit the parties in power in each house. And mapping was done entirely in secret by LAT4 with very little public input. So LAT4. LAT4, the body within the legislature that used to be in charge of map making. So the main goal of reform from our perspective at that time was to limit the ability of one party to drive another party off state or off a district, and to distance the pen from the lawmaker, and to create a more open map making process. Now, a lot of people today criticize the 2014 amendment and it's kind of like not enough. But I want to remind us that for decades and decades, redistricting reform was just a hope or a non-starter. And just heading into the 2010 cycle, redistricting cycle, the stars aligned. And that included some vocal reformers in the legislature, a public campaign by then Mayor Koch, a broad coalition of good government groups, and other advocates, and importantly, campaign promises made by Governor Cuomo at that time, who threatened to veto any gerrymandered map or a non-independent map. And also political circumstances in the legislature that encouraged compromise. So we should just remember that long before 2014, many reform attempts failed. And New York is not a ballot initiative state, which means it was clear to everyone at the time that the legislature is unlikely to pass any legislation that would fully remove its power from the process. Even the leading proposals before the 2014 amendment at that time, and they were carried by our current deputy majority leader in the Senate, Mike Generis, and our current minority leader in the House, Hakeem Jeffries. They were behind the leading bills at that time on redistricting reform. Even those bills kept the final appointment power with legislative leaders and the final say on the maps with lawmakers. The California model of citizen-led redistricting was not even, it was just getting started. It wasn't even a well-proven model. So just to remind us the context under which the 2012 amendment, started in 2012 amendment, was conducted. And our goal and goal of many other good government groups was certainly to have, to get a stronger reform. But in a typical Albany fashion, the final stretch of negotiations were done behind closed doors, out of our hands, no time for debate, late night, negotiations, deal, and a vote. So we didn't get everything we wanted in that amendment, that's for sure. We wanted an odd number commission. We wanted the 2% rule to be inserted in the Constitution. We wanted the Court of Appeals to get original jurisdiction, so we won't have forum shopping, and a few other things. So, on the process side, I think the 2014 amendment left much to be desired. But on the criteria side, on how and what kind of maps we should draw, I think it did bring major beneficial changes. So Voting Rights Act, VRA type protections were inserted in the Constitution, and I think it is even more important today, as we see the Supreme Court slowly gutting the federal VRA. We indeed got expansive anti-gerrymandering provisions in the Constitution, one that forbid both party-based gerrymandering and incumbent or candidate-based gerrymandering. We had population equality inserted and other basic standards like compactness, considerations of communities of interest, and others. Of course, I'm kind of oversimplifying this, right? So there were good things that were inserted into the process, public hearing, and there were some bad things or non-sufficient things that were inserted into the criteria side of the amendment. But at its core, that 2014 constitutional amendment represented a bipartisan agreement that, while not perfect, reflected a reasonable political compromise to an inherently political process. In my view, the logic of that amendment was that the new constitutional criteria, mapping criteria, and the threat of judicial oversight would act as sort of guardrails or maybe even deterrents against any future attempts by lawmakers to misuse the power they kept for themselves in this compromise. And I think looking back at the 2020 redistricting cycle, that proposition proved correct more or less, although proving it correct was not without costs. So, as deadline approached, it became clear that lawmakers are pretty much seeking to ignore these guardrails. Mr. Faso, I think, gave an excellent rundown of all the different ways in which they've done that. So I'm not going to repeat that. But I do agree with a lot of his characteristics. And of course, I don't believe it was only the majority party to blame. We saw just lack of collaboration and issues with how the IRC worked as well. And of course, a final critical decision to approve maps in the legislature that, at least in their congressional version, were so clearly an attempt for a partisan gerrymander that I think it was hard for even a court of appeals, as Ms. Simmons said, that usually goes with the majority party to ignore. Again, I think both the majority opinion and minority opinion there did not ignore the partisan gerrymandering. So just to summarize those, I think constitutional guardrails did work to prevent the misuse of a new system, especially the partisan misuse of this new system. And ironically, it did end up producing much fairer maps than what we had before 2014 and previous cycles, at least in terms of the partisan gerrymandering or partisan gerrymandering of the majority parties in each house. We could have gotten those fair maps 3 years earlier if the majority and minority parties had collaborated, and if we would probably have seen a more goodwill among the different players in this cycle. Yet I just want to end by saying that looking back, I think the biggest harm done by the way this new system unfolded, or one of the biggest harms, or the biggest harm of this, the logic of that 2014 compromise that I described, is that it fueled public cynicism over redistricting and over government in general. It just hurt public trust of that process in I think ways that are hard for us to think about. The many twists and turns, the split primary, the last minute maps just kind of pulled out of a hat. The perceived disregard for the efforts of so many New Yorkers who showed up to testify at hearings and were then ignored by lawmakers who did not really care about their testimony. The lack of any explanation of why maps were drawn one way or another. Only our special master provided very helpful report about explaining how he draw the maps, which probably this room are the only people that might have read. I think for me, that is the clear reason, that's kind of the clear goal when we think about future reforms. We should remember that building an effective process that actually works is not only a question of what maps are eventually drawn, but also a question of promoting and improving public trust in those maps and government in general. Thank you.
Thank you, Ben. And to close out this panel, I'll invite Cesar Ruiz from Latino Justice Pro-Def to meet with us.
Certainly a hard group to follow, but I want to start off by thanking Jeff for gathering us, and also Director Romalewski for drawing an incredible tool that we use to educate and engage community members. We've heard a lot about partisan politics, but our centering is racial justice, and that lives in the communities that we serve and the constituents that we champion. I'd also be remiss to not name members that were a part of the team. While you see me here, my colleague Fulvia Vargas de Leon was a big part of our efforts, and our national redistricting director, Lucia, will be here wearing another hat, but she was critical to the process to build accountability in one that had many twists and turns where communities were left out of that process. So I think a few table setting things are important. First, the loss of Section 5 and pre-clearance was huge. It created a fire across this nation, not only in this legislation that was passed, but in redistricting. It really informed the way that every group showed up and spread resources so thin that it was such a fast-paced process that really alienated a lot of folks, and that cannot be underplayed. The second piece, we talked about the census, but I think we missed a huge part of it, is that it was politicized. There was an attempt to add a citizenship question at the end that created delays and also scared off communities of color that disproportionately created the growth in this state. We missed, I think, by less than 100 that one seat. And I can tell you that there were more than 100 people in this state. And there's an open question of whether the citizenship question created that harm. I can tell you from the perspective of the Latino community, a community that has mixed status families, that was a decisive factor in many of those individuals wanting to engage with that question. And the fear mongering and the mis and disinformation that played into that was why we lost representation. So those, I think, are important table setters to kind of set us off. Now we talk about the process. Because everything was delayed, it created a lot of gaps in knowledge in the communities that we have to engage. Redistricting is a process that follows the census. We know the census was delayed. We know that the numbers were delayed. And so the engagement that happened also had to happen in another historical event, the pandemic, which I don't think I have to remind anyone. So we're talking about what is already a monumental challenge and then having to engage virtually, which was new to everyone at that time, and performing that within historically marginalized groups. We're talking about Black, Latino, Asian communities, communities of color that don't have the same level of access to materials and have not been engaged in this process historically because they've been disadvantaged and thrown to the side. And so with that backdrop, our intention was really to center the voice of the community and do as much education, as much outreach, and build as much awareness about this process at a time where people's last concern was voting. People were thinking about their livelihoods. People were thinking about their families. People were thinking about their health. And that was no small task. And so we are a part of the Unity Coalition. It's Latino Justice PearlDef, Asian American Legal Defense and Education Fund, the Center for Law and Social Justice, of which Esmeralda is a longtime architect. And I will say she's retired, and she,
You're right.
in air quotes, because she was deeply involved in our process. And so our process was gathering community stakeholders and trying to build a map that equitably reflects racial minorities, understanding that racial minorities have been historically underrepresented in the maps and been used as political pawns in this game where we always lose. And so our ultimate driver was to bend the arc. We talk about Dr. Martin Luther King's dream, and it's an open question of whether that's been achieved because we see some of the rampant discrimination rearing its head again and again and again. And that really is what drove our process. It was not a zero-sum game for us. We had to come to the table with all of our constituencies to think, how do we create a fair map based on equal population, based on the Voting Rights Act, based on communities of interest that are developing and emerging. And that really drove our process in a nonpartisan way. We are all nonpartisan groups, and we had to think creatively of how do we protect the political power that some of these groups have already been able to build by electing candidates of their choice that represent their interests and have championed their interests. And that was a big driver. The second piece is how do we respect the growth among communities that disproportionately grew and that represented the change in the communities that we've seen. And that is no small task. I can tell you we spent hours and hours with expert map makers trying to think through the very difficult questions that come with shifting populations and shifting people into areas. We thought we had a thankless job. I'll give that to the commissioners. It is not a zero-sum process. It is a lot of painstaking collaboration, a lot of conversations that have to be centered on what is going to move the needle for communities and what is going to respect the way that they identify their communities. And how is that possible with the restrictions that exist in the law to meet that mandate? What came out of our process was a map that represented our best effort. It's called the Unity Map. We had all 3 levels, and we took the show on the road with all of our partners. We showed up to almost every hearing. Unity Map is etched into the record in many, many ways. The late, great Dr. Flato gave us plenty to think about and plenty of back and forth, but it informed a process that really centered the people's will. We engaged community members to educate them using tools that historically hadn't been accessible. Esmeralda would always tell me that, they had to physically draw the maps, and that all of this new software created an opportunity to really make it accessible. And we tried to drive that access. I think our biggest point was, it's not that this map is going to be drawn every which way we like it. We have the Unity Map. We're going to, rally people around that. For us, what we wanted was fairness in the maps. And so once we took the show on the road, the process that followed was the litigation, right? We knew that the outcome was a 5-5 split. They submitted 2 maps, and then the legislature just came out with their own. And so that created a rat race for us to get into a position where we now have to deal with all the twists and turns that come with litigation. Now, Latino Justice, we're a litigation shop. We know how that goes. But we can see that this process was unlike really any process that had ever played out. Despite the historical implications of the backdrop that we're dealing with, no map had ever been struck. I think it was like 60 plus years. So decades and decades of deference to the legislature. And that was a huge twist and a huge turn. We had to drive all the way up to Steuben, where I got to meet Dr. Serapis. And we had to engage in that process. And that was a 5-hour drive. We were in the middle of nowhere, New York.
Oh, come on. Steuben
relative
County
to
is
us,
beautiful.
It is beautiful. So, but to us, it was no small
Don't
task.
say that.
It was no small task. And I don't want to downplay. I know there's a lot of history. There's glass making. They have a rich, but to say it's representative of the state that is incredibly diverse would be a misstatement of facts. And what we knew was that the map was drawn by a special master, and what we saw come out of that process was not enough to sue on, but a process that was more fair than what we had seen. But we knew that that process was not over. And we knew that partisan politics would again move to shape what the reality of that was. And that's what we saw with Hoffman. And I can tell you from the ground, I think Esmeralda mentioned it, this process is still playing itself out while other local redistricting processes are playing. So when we talk about, we didn't just stop at the statewide level. We do New York City redistricting. We do redistricting out in Nassau County where we have active litigation. We have a responsibility to bring the show on the road everywhere we go. And having this process be drawn out and play out in the ways that it did really created a lot of obstacles for us to be everywhere where resources are already thin, where we already have our work cut out for us. We draw maps not only for statewide level, but at the local level, and try and inform and shape those processes on the local level, understanding that power is not derived just by Congress. It is derived by all of those local bodies that shape the politic of the larger discourse. And that to us was a huge discredit with all the twists and turns, with all of the partisanship really taking an oversized role. I think we reflected on the fact that it's a process that really shut out communities of color, but communities writ large, and voters were super alienated. When we were talking about having to re-engage community members and engage them on the issues that impact them, they were, distraught. They were saying, how many times do we have to go through this? We have bigger issues. We don't have the resources to really turn and engage in this process. And the ultimate product that you see is not one reflective of the public discourse that ultimately should inform the map-making process. And I'll end just by reflecting, I think, on things that we learned this cycle. This process has to be driven by the communities that it serves. It has to be driven not by politicians or political interest, but by people who will be represented by these maps for the next 10 years. And structurally, we have to reconsider, and I know the next panel will touch on this, we're part of the working group to really reimagine that process. Structurally, the problems that flowed from that really dealt with the fact that it is an even-membered commission, which is not functional. The second piece of it is transparency. We have to have the ability to build accountability into each step, and the fact that all of these negotiations are not held out in the public is a detriment to all. The third piece, and probably the most critical, is that we cannot have an advisory commission. This cannot be one that can be kicked back to the legislature. It has to be one that's truly independent.
That's right.
And for us, that's a lot of what will drive our work in the years to come. So I want to thank Jeff and all of our great panelists for sharing their thoughts.
I want to thank all of our panelists for great presentations. Our final panel, and I shouldn't really say final because our closing comments will come from Bridget Bergen at the end of the next panel. So let me invite David Imamura, Laura Bierman, Liz Uyang, Mohammed Amin, Grace Pune, and Lucia Gomez to the table. And Ben Max of New York Law School Center for New York City Law will moderate that panel. Thank you. I think his presentation is over. And you have to leave when you're. Okay. And you can.
So how's Jennifer Wilson doing these days? I miss her.
We're going to give everybody just a quick minute to grab a snack, but we do need to keep moving here. So
Oh God. Since I saw her, because I do election litigation, I saw her. Like,
Okay.
is that the same Jen Wilson?
Yep. So it just, yeah, no, it was a good move.
Yeah.
I'm going to have our next panel get going here in 30 seconds. If everybody can grab your snacks and grab your seat again, please.
Do you live here in the city?
No.
Oh, you came down?
No, I
from-
wasn't. I mean,
Wow.
I
You are a
wasn't
good
part of
person.
it. Well, we're the state league. We have a local league here.
Yeah.
We have 42 across the
Yeah.
state.
Oh, got it.
So,
Got it. Yes,
But
okay.
yeah, the deputy director and
Yeah.
I came down
Oh, okay.
today.
So I, as a Westchester County legislator, I have Kathy Meany tell me
Oh.
how wrong I am. A lot.
Yep, she's now on our state board.
Yeah.
Yes, yep. Wow, you get a lot of interaction then with us.
Yes, well, I'm a big fan of the league, right? Like,
Good to hear.
having won in a special election where the league said everyone should vote.
Yes,
Hi.
hi. I mean, I'm here.
Here.
We're in order, I think.
Yes, hi.
Happens structurally is.
All right, we're going to get going with our panel here. Thanks again, everybody, for being here. I think before we start this,
Let's see.
before we start this next panel, if I could ask everybody, I think everybody will agree with me on this. Just a quick round of applause for Jeff Weiss, who has brought us all together here today and kept us all so well informed on everything that happens in New York redistricting and nationally as well, and just does such a fantastic job on these issues, and not just redistricting, but also election law and census work as well. And again, thank you to Jeff for bringing us all together here today, and the rest of the team here at the Center for New York City Law and Jeff's Institute. All right, we are a tiny bit behind schedule, so let's get right into it. I'm going to have each of our panelists here just briefly actually just introduce yourself and get right into your remarks so that we can make sure to keep our program moving here. But I just want to, in addition to thanking Jeff, thank all of you for being here, thank our team at the Center for New York City Law, and thank our great presenters and panelists thus far. I don't know about you, but I've really enjoyed it so far today, and I'm sure this panel will be extremely interesting as well. So, David, take it away, please.
You want us all to introduce ourselves one by one?
Oh, no, as you go.
Okay.
We'll just, everybody's got the program, everybody's got the agenda, so we're not going to take a lot of time with bios and introductions, so please go ahead.
All right, so hello, my name is David Imamura. I was the first chair of the New York State Independent Redistricting Commission. I stepped down in the fall of 2022 after to run for the Westchester County Legislature, upon which I informed State Senate Majority Leader Stuart Cousins I was stepping down, and I said to Ken Jenkins, tag you're it, you're the new chair of the State Redistricting Commission. It's funny because for me, the redistricting process, I feel like I've grown up on the Redistricting Commission. I was the youngest member of the commission when I was appointed. And to this day, I think the reason I became the chair was because when COVID hit and the commission was just starting, I was the only one who knew how to set up this thing called Zoom. Right. And so I was the one who was doing the administrative processes for the 10 commissioners of setting up Zooms to start things. And so that kind of glided into, oh, you should be chair of the State Redistricting Commission. It was funny because when I was a 2L in 2014 at Columbia Law School, it would never have occurred to me when I was voting for this referendum that I would have ended up as the chair of the Redistricting Commission. So to the law students in this room, you too can be chair of the State Redistricting Commission one day. But it is a thrill to be here. It is a thrill. Thank you so much to Jeff. Thank you so much, Ben. Thank you so much to New York Law School for putting this together. I think this is such a critically important issue. I think I do want to pause and I want to recognize, we've talked about this before, but I want to recognize John Flateau, who was the chair of, who was one of my fellow Democratic commissioners on the commission. And it's funny, I remember having a conversation with him where, so my wife gave birth right the day that the census results came out. And so to our first child, and I spent a lot of time at 3 a.m. reading law journal articles about redistricting. And I remember finding that the 1983 redistricting case was John Flateau versus State of New York, I think. And I said to John, well, John, I didn't realize you were the named plaintiff in the 1983 litigation. And he said, well, David, I pass this on to you now. And I remember at the time thinking, oh, this is just a joke about me being young and him being older. And now I realize that was him passing the torch onto the next generation of people who, for better or for worse, are interested in redistricting and realize the importance of this process, realize how essential it is to ensuring that all New Yorkers are represented. So to get to this process, so I often feel when Ken Jenkins and I speak, that I am the redistricting bad cop to Ken's good cop. Because Ken sits here with John Faso and says, we did great. We came up to the whole commission came up to a single plan. We voted 9-1, we got it through. So I'm here to talk about how the Redistricting Commission completely failed in its mandate to reach a single agreement, right? So I'm gonna take you back a couple of years from when Ken was chair to the dark days of 2021, when the commission failed to reach an agreement. And this gets to the subject of this panel, what needs to be changed going into 2030. Because right now, as it stands under the New York State Constitution and under the precedent under Harkenreiter, the current redistricting process for the state of New York is completely unworkable. And we are destined to repeat what happened this past cycle in 2030 unless we change it. So it's been alluded to the problems with the commission. It's 5-5, 5 Democrats, 5 Republicans. What hasn't been alluded to is that the Constitution also has a 7-member quorum requirement. So what happened for us was that, just taking a couple of steps back, the Democrats and the Republicans on the commission in the first go around largely agreed on 90% of the maps. It was the last 10% we couldn't come to an agreement on. And so we were, and I remember distinctly, like during the holidays, screaming at my Republican counterpart about, individual districts. But we just couldn't reach an agreement. So then the question was, all right, well, what happens now? The state constitution does not specify what to do, right? There had been a referendum, there had been a ballot proposition that would have addressed this, right? What happens when the commission fails to reach an agreement? So the Democrats said, well, we should vote out one set of maps. The Republicans should vote out a separate set of maps. The Republicans said, no, We refuse to participate in this process because we don't want to vote a set of maps to the legislature precisely because there is this lack of clarity on what's happening. And then ultimately, when it got to the Court of Appeals, the Court of Appeals said, well, because the commission failed to vote 2 sets of maps out to the legislature couldn't act. And it's clear in retrospect that the Republicans intentionally deprived us of a quorum, deprived us of being able to vote 2 sets of maps to the legislature because they did not want the legislature to be able to fill in the void. They wanted to force a process where a special master would have to draw the maps, right? So it will currently, under the current system, it will always be the case that one party or another might have the opportunity to completely fail the commission because of this 7-person requirement, because we couldn't even have a meeting without 2 of our Republican colleagues agreeing to show up. And the Republicans said, we will not show up to a meeting if you call one. And we talked about, and some of my Democratic colleagues are here, we talked about having like a press conference saying, well, this is a semi-meeting, that we could try to do this. And we said, you know what, this process has already become a circus. We don't want to make it even more of a circus. Now, little did we know it would become even more of a circus over years and years and years, right? But at the time we said, you know what, let's just let it go. The Republicans are refusing to come in, refusing to have a meeting, just let it go. And that we should remember that at the time, there was a law passed by the legislature, signed by the governor, that said that if the commission failed to reach an agreement, the legislature would take over the process. The Court of Appeals then struck that down, right? But at the time, we didn't realize that the Court of Appeals would strike that down. So we adhered to the law as we understood it at the time. So the issue right now is I think, and this was talked about before, the 2014 amendment had a lot of good intentions, right? But there were probably deliberate issues built into the system structurally that prevent us from being able to reach an agreement, right? And it took literally 2 Court of Appeals cases, a special master map, and then a court mandate to act for the commission to reach an agreement, right? We should not have to do that a second time, but we will, or we will at least run the risk of that happening unless there is some change to the map. I'm sorry, to the structure of the system. Now, what changes should there be? I think it was Tolstoy who said that all happy families are alike, all unhappy families are unhappy in their own way. That's definitely true for redistricting, because what happens is states that do it right are all the same, and states that do it badly in different ways, right? So, California, I think, is a prime example of a good system, right? There's an odd number of commissioners, but it's also odd, but I think it's 4 Democrats, 4 Republicans, and like five independents, right? So there's not a single tiebreaker like there is in New Mexico or New Jersey, a single tiebreaker who actually will often get death threats from the public, right? There's not a single tiebreaker. There's multiple independents who are acting as tiebreakers. That also lends itself to a system where it is not, political appointees. I was a political appointee. I would also say maybe you should do what California did, where they literally hold a lottery to determine who should be a commissioner on the California Commission. Like, you put a bunch of names in the hat, and then, hey, you're drawing the maps for the entire state of California. That's something that the state should consider. And I think that would be very helpful for us going forward. The other element of it is, I would say that, transparency, right? We fully admit, right? The Democrats and the Republicans kind of went into our silos, drew our own maps, and then came together and tried to figure out common ground, right? In California, they will literally live draw the maps in public, which I think is insane because it makes everything take a lot more time. But they will literally sit there for literally weeks and have a Zoom, and people can watch them draw the maps live. And then people will be getting input live as they're drawing the maps, right? I think that's something to consider. And I think that is something that comes out of a system that is not 5 Democrats and 5 Republicans. But I will say that no matter what happens, we must change the system, because otherwise, those who don't learn from history are doomed to repeat it. We've seen how this happened here now, right? And I am here to tell you, as the first chair of the Redistricting Commission, that the Redistricting Commission is destined to fail unless we change it. So again, thank you all so much. Really appreciate it, and happy to pass it on to League of Women Voters.
Thank you.
Thank you. Thank you. Please take it
Good
away.
morning. I'm Laura Ladd Bierman. I'm the Executive Director of the League of Women Voters of New York State. The League has long dedicated promoting fair and effective redistricting. We were strong supporters of the 2014 amendment, believing it was our best opportunity to obtain long worked-for reforms, establishing an independent redistricting commission and a process that included robust anti-gerrymandering provisions. However, unfortunately, the first experience with the new process fell short of our hopes for success. Despite the challenges along the way, our organization worked diligently to advocate for the commission and the process. We actively participated in efforts to secure the necessary funding and provided extensive training for our members and the public. We taught individuals how to engage in the redistricting process, utilize mapping software, and present testimonies at hearings. Our commitment to educating the public was recognized by both the media and members of the IRC. Finally, we submitted an amicus brief in the Harkenrider case in 2022, urging the Court of Appeals to uphold the process approved by the voters. We believe, however, that we can do better in New York State. The new process showed significant weaknesses, and the independence we sought was not fully achieved. As a result, the League is now part of a coalition, alongside many of the organizations present today, exploring new and improved processes for redistricting in New York State. The most important question in considering reform of the redistricting process is whether the legislature should still play a role, or if the process can truly be independent. Given that New York State does not permit citizen initiative and referenda, any potential proposal must be viable with the legislature. Removing the legislature from the redistricting process entirely would be the ideal situation, as demonstrated by successful implementations of independent commissions in other states and cities across the nation. However, we must confront the challenge of whether the legislature would be willing to relinquish its control over this process. The primary concern for any legislator is re-election, and ceding control over redistricting would mean accepting the possibility of increased electoral competition. Therefore, we face the paradox of depending on those who are most adversely affected by this change to agree to this change. This necessitates a strategic approach to garner legislative support for a more independent process. It involves highlighting the long-term benefits of fair and representative districts and building a broad coalition to advocate for these reforms. We must continue to engage, educate, and mobilize the public to create a groundswell of support that legislators cannot ignore. Let's start at the beginning, though. I see 5 main areas for consideration in potential reforms: commission selection process, operation of the commission, voting and decision-making by the commission, final approval, and appeal. A key reform in the redistricting process should address the selection of the commissioners. Commissioners should not be appointed by the legislative leaders. Extending the prohibition on past office holders or party officials from serving as commissioners to 5 years would further safeguard the commission's independence. Additionally, a new prohibition should be introduced to exclude anyone who has donated above a certain threshold to a candidate or political party in the same 5-year period. Expanding the commission to 11 to 15 members, maintaining an odd number for decision-making purposes, would enhance its functionality. Representation on the commission should include members representing unaffiliated voters as well as the 2 major parties. Each group should have equal representation, such as 1/3 from each category. This would ensure a more balanced and fair representation of political perspectives. Our current Constitution mandates that the commission, quote, shall reflect the diversity of the residents of this state with regard to race, ethnicity, gender, language, and geographic residence, end quote. Further reform should uphold this diversity requirement and specify that the commission's composition reflects the demographic percentages of classes protected under the Federal Voting Rights Act. How do we get the commissioners selected if appointments are removed from the legislature? First, a comprehensive system of outreach to various communities statewide to recruit applicants must be undertaken to ensure diversity in the applicant pool. An office created within a neutral agency should manage recruitment and initial review of the applicants. In California, this is in the state auditor's office. Elsewhere, it's in the court administration or possibly the Secretary of State's office. This staff will organize the recruitment effort, develop the application, review applications for their compliance with criteria established by the legislature, and then forward those meeting the criteria to an applicant review panel. This review panel will have similar prohibitions to serve as the commission has on. It could be a panel of retired judges or people in the auditor's office, but not political appointees. The review panel would receive and review the applications who have met the criteria and possibly conduct interviews. Once they've reduced the list further, the process could allow for the legislature's input at this point, not with appointments, but with a limited veto power. Then the list would return to the staff agency where a lottery of the candidates would be used to select half of the commissioners. The applicants must be divided into parties and unaffiliated candidates to ensure the correct proportion of each. This first half of the commission would then select the other half from the same pool of applicants, striving to ensure the diversity of background, geography, and skills and abilities for the commission's work. The commission is responsible for selecting the chair, hiring staff, and determining its meeting schedule. All of their work should be in the open and allow for public input. The public should be encouraged to draw and submit their own maps and have the opportunity to provide input. The current 12 public hearings with geographic distribution listed in the Constitution is a good one. In some states, mapping software is made available to the public to encourage their input. The constitutional criteria for redistricting should be revised to prioritize the anti-gerrymandering provision. The first and foremost criterion shouldn't be ensuring that districts are drawn without favoring any political party, candidate, or incumbent. Following this, the second consideration should be the maintenance of communities of interest. Ensuring that anti-gerrymandering is a top priority will help prevent manipulative practices that distort the democratic process. Meanwhile, emphasizing the importance of maintaining communities of interest will enhance the responsiveness and accountability of elected officials to their constituents. Decisions of the commission should be by majority vote. With representation by the two parties and unaffiliated voters, a majority vote will hopefully prevent one party from controlling the output. Ideally, the maps proposed and agreed upon by the commission should be the final maps, as is the practice in several other states and cities. However, realistically, this may not be possible to achieve in a state without voter initiative. If the maps must be submitted to the legislature for approval, additional safeguards and prohibitions should be enshrined in the Constitution to protect the integrity of the commission's work. Allowing the legislature to draw their own maps after voting down the commission map undermines the purpose of an independent commission and is totally unacceptable. If the legislature must retain final approval, then strict constitutional restrictions on changes are essential. For example, the 2% statutory rule, which limits population deviation between districts, should be included in the Constitution to ensure that the legislature cannot choose whether to abide by it. Other restriction on how the legislature can change the proposed maps should be in the Constitution to limit their control and power over the process. The reform should also include an appeal process if the commission deadlocks or cannot meet its constitutional obligation. The legislature should not be the default if the commission process fails. The court's role in this situation should be spelled out in the Constitution. Two general revisions must also happen. All old sections of the Constitution referring to the current commission and LAT4 must be removed. And a specific line item should be included in the budget process for the commission and its work to avoid the delays in funding that occurred this past cycle. By implementing these reforms in the Constitution, we can safeguard the redistricting process from partisan manipulation, ensuring it remains fair, transparent, and representative of New York's diverse population. The League advocates for a truly independent redistricting process, but realizes the political realities within New York State. We are working within the Reform Coalition with many other organizations in the attempt to develop a new process that is as independent as possible for the 2030 redistricting process. Thank you.
Thank you. Thank you.
Hi, my name is Liz O. Young. I'm the coordinator of APA Voice, Redistricting Task Force. We are the largest Asian Pacific American redistricting coalition in New York. We started after, we became involved in the 2010 redistricting cycle when we were initially 5-member organizations. We have grown to over 20 organizations in the 2020 redistricting cycle. I'd like to recognize Juan Jia Lee, who is also part of the coalition, and Aaron Fernando, who also helped in many ways, who's in the back as well. Our coalition is composed of health organizations and groups who protect affordable housing, offer food pantries, conduct legal advice, free legal advice clinics on health, immigration, and other basic benefits, and provide culturally competent child, educational, and senior services. We are in the trenches. From CPC, the largest social service organization serving APAs throughout New York, to South Queens Women's March, a volunteer small organization empowering South Asian women, we are the voices of the diverse and growing APA communities in New York. That's why the very systems that allow communities to be empowered must be accessible, fair, accountable, and transparent. We need to get this right. New to redistricting in 2010, we were not involved in crafting the 2014 amendment. But following the 2020 redistricting cycle, APA Voice Redistricting Coalition is part of the coalition that Laura mentioned, spearheaded by Common Cause to reform the Independent Redistricting Commission. Composed of nonpartisan good government as well as community-based civic engagement groups, we've been meeting for a year now, and we hope to have a reform proposal to share in fall of this year. But let me just highlight some of the things that Lauren did mention that we have discussed in our coalition. Overwhelmingly, there needs to be a truly independent redistricting commission, an overhaul of the existing system, not tinkering the current system on the edges. Because of the inherent conflicts of interest, the legislature cannot have final say on the maps. The IRC that went into effect for the 2020 redistricting cycle was hardly, quote unquote, independent, rather a classic case of the emperor without his clothes. This was a 10-member commission split evenly between two major political parties, no matter if their proposed party maps were camouflaged as Plan A or Plan B. When the commission deadlocked along partisan loyalty, it was the Legislative Task Force on Demographic Research and Reapportionment, LATFOR, who then drew the congressional and state lines. LATFOR was the very body that voters in 2014 wanted to strip of their power to draw lines because it is mostly composed of elected legislators. What followed was more partisan bickering in a series of lawsuits in which one court found the lines that LATFOR drew to be unconstitutional. This court then appointed a special master, as we know, Jonathan Cuevas, to draw the congressional lines before the 2022 congressional primaries. Another court ordered the IRC to redraw the state assembly lines, and another court ruling ordered the IRC to redraw the congressional lines before the 2024 congressional primaries began, thus replacing the lines drawn by the special master for the 2022 elections. During this 3 plus years of back and forth between the IRC, the legislature, and the courts, it was the community who was caught and stuck in the middle. It was critical that communities weigh in on any new set of proposed maps, because these maps, as Cesar said, could be in effect for 10 years. And a true democracy requires full participation. Communities, those of us in the trenches working on a dime, were forced to mobilize and testify in multiple hearings as a result of this back and forth, or to respond when the IRC and LAT4 acted unilaterally without holding public hearings. The communities are a necessary check to efforts by the IRC or legislature to put partisan interests over keeping communities of interest intact. And it shouldn't take the courts and a special master for those advocating for communities of interest to be respected and heard. The second needed reform dealt with the diversity that redistricting is required in New York to consider. The composition of the IRC in 2023 and 2024 fell short in obtaining a commission that reflected the rich diversity of New York City. Asian Pacific Americans are the fastest growing group in New York State. Based on the 2020 census, APAs constituted approximately 11% of New York State's population, a 36.7% increase from 8.2% in 2010. Yet the composition of the 10-member Independent Redistricting Commission in 2023 and 2024 did not reflect this growth. There were two opportunities to better reflect the diversity of New York State in the composition of the Independent Redistricting Commission, but those attempts fell on deaf ears. The third reform deals with transparency and APA Voice Redistricting Task Force Coalition member, Caribbean Equality Project. Mohammed Amin, the founder and executive director, will now address this issue.
Thank you, Liz. I first want to thank Liz for sharing her time with me today. My name is Mohammed Q. Amin. I'm the founder and executive director of Caribbean Equality Project, and we are a Caribbean LGBTQ immigrants' rights organization based in Richmond Hill, Queens. And many of you might have heard Richmond Hill, Queens in the press for the past 3 years. I have to say, in preparing for today, I feel like I've been re-traumatizing myself. Because that's what it was trauma. We know redistricting is a civil rights issue, but the 2020 cycle proved that it's also a racial justice and immigrants' rights issue. After the 2010 redistricting, it left Richmond Hill and South Ozone Park community of interest fractured into 7 assembly districts. From 2010 to 2020, this form of political disenfranchisement and gerrymandering diluted the South Asian and Indo-Caribbean communities' votes and voices for over a decade and decades prior. During the pandemic, it exacerbated funding inequality and lack of government resources to combat COVID-19. In October of 2020, zip codes 11419 and 11420 had the highest COVID-19 positivity rates, which led to death and family separation. Richmond Hill and South Ozone Park were among the last communities to receive COVID-19 testing and vaccination sites. Many of the community members we lost were mainly immigrants, seniors, caregivers, people with disabilities, essential workers, and undocumented people. Many of these folks were also my neighbors. During the first round of redistricting, APA Voice convened a citywide coalition of AAPI-led and serving organizations to advocate for fair maps. We hosted car tours and art contests to engage young people, organized educational town halls, hosted virtual and in-person press conferences, and mobilized community members to testify virtually and in person at the hearings throughout New York City. After the IRC deadlocked and the state legislature drew the lines, the state legislature was sued. And after the court ordered the IRC to redraw the lines. During the winter of 2022, APA Voice held an emergency rally in front of 250 Broadway to demand that the New York State Legislative Task Force hold a public hearing to ensure our community's concerns were not ignored. The IRC's second draft significantly differed from the IRC draft significantly differed from the second, which was submitted to the IRC in the first round, and what the state legislature proposed. For the first time in history, the draft map 8024 was proposed, which kept Richmond Hill and South Ozone Park in a single assembly district. To support 8024, that the IRC itself proposed, APA Voice Coalition members wrote op-eds. We met with over 35 New York State Assembly, Senate and Assembly members, hosted another round of press conferences to advocate for various proposed maps, including 8024. Caribbean Equality Project and our community partners in South Queens hosted a second community educational town hall. We mobilized young people, faith leaders, elected officials, teachers, essential workers, and community leaders, including LGBTQ people, to fearlessly advocate for draft map 8024. At the February 2023 Queens hearing at York College, almost 80% of the testimonies came from APA Voice Coalition members. We dominated that hearing and felt victorious. On April 24th, 2023, the IRC suddenly reversed course and abandoned its own draft map 8024 for Richmond Hill and South Ozone Park. The IRC's final proposal maintains the status quo by cracking Richmond Hill and South Ozone Park from 4 assembly districts to now 4. From 7 assembly districts to now 4. In doing so, the voices of the Indo-Caribbean and South Asian communities of Queens continued to be silenced. The IRC proved that its hearings were performative and perpetuated racial gerrymandering and disregarded our already underrepresented and marginalized immigrant communities of interest in South Queens. To get answers and demand transparency and accountability, on April 24th, the APA Voice Redistricting Task Force organized a press conference in Richmond Hill to oppose the New York State Independent Redistricting Commission Assembly map sent to the New York State Legislature. APA Voice filed a FOIL request with the New York State Independent Redistricting Commission. We were told that the Freedom of Information law did not apply to the IRC. Supported by APA Voice and led by Caribbean Equality Project, we launched a public petition to demand transparency from the New York State Independent Redistricting Commission. Through online and street outreach in Richmond Hill and South Ozone Park, we got over 1,200 signatures in just 3 weeks. On September 11, APA Voice Redistricting Task Force held another press conference in Richmond Hill to seek transparency from the New York State Independent Redistricting Commission and the New York State Assembly Speaker, Carl Hastie. We attempted to meet with the Assembly Speaker, Carl Hastie, multiple times about why the legislature adopted the IRC plan, knowing the IRC drew a draft map that kept Richmond Hill and South Ozone Park together. To date, Speaker Hastie has refused to meet with us directly. We still don't know why the IRC abandoned its own draft map, Assembly Map 8024, which had overwhelmingly community support. The obvious answer is to protect incumbency. The 2020 redistricting cycle ended with a divided Richmond Hill and South Ozone Park, but it also created community mistrust with the New York State Independent Redistricting Commission. Our community members listened and believed the IRC calls for testimony. We trusted that our voices would be heard and given priority in the redistricting process. In record numbers, we fought for fair maps and for justice for Richmond Hill, but instead we were ignored and silenced. The New York State Independent Redistricting Commission demonstrated that they do not believe in transparency and accountability. We must now move beyond these binary demands to explore strategies to reform the IRC. This must be done in a collective effort because historically, Black and Brown immigrant communities are the ones continuing to experience racial gerrymandering, neglect, exclusion through the redistricting process. Thank you.
Thank you. Please.
Hi. Hello, can everyone hear me? Okay. So my name is Grace Pian, and I had the privilege to serve as the general counsel for the New York City Districting Commission. So, you know, I think a common refrain has been today in this room has been about the contributions of Dr. John Flatteau. And I was one of the beneficiaries of his kind of generational mentorship and in the New York City redistricting process. And New York City, it was his turf, you know, and he had the knowledge and resources to relatively help this process go smoothly. I think maybe everybody was also beating up on the state so much that the city was able to go by relatively unscathed, but it was by no means an easy process. And I just wanted to acknowledge, I think it's like a little mini reunion here. We have Commissioner Collado, who loved it so much that he decided to do the commission on the state level. We had Commissioner Judge Go here as well. And I think that in the context of talking about reform on the state level and just reflecting back on how New York City did it, I think we had the advantages of charter language and a legal structure that helped us. And I think it would be helpful to point out how the New York City charter and how that process worked and kind of the benefits of the language that was there already. So one piece is that the appointment of the commission, obviously we had the privilege or the advantage of not having to be so bipartisan because, you know, New York City is overwhelmingly Democratic for most parts. And so the way the charter structure is set out under the New York City Charter, which governs New York City redistricting, this is Section 2A for the lawyers out there who want to look it up. The commission is made up of mayoral and city council appointees. And the dynamic is such that the mayor gets 7 and city council gets 8. And within city council, the majority party in power, so in this case, the Democrats get to choose 5, and the minority party, the Republicans, second largest party, the Republicans get to appoint 3. And in that case, so the dynamics there, you obviously have a 15-member commission, a chair that's appointed by consensus of both the mayor and city council, where you don't necessarily have that that gridlock happening. And of course, you know, that's not to say that the commission doesn't have its own share of different dynamics based on the administration, you know, of the time of that redistricting cycle. You know, the mayoral dynamics with city council very different this time around than it was 10 years ago. So we had the own issues there, but overall, I think the makeup of the 15-member and then just having something that's not bipartisan was to our advantage. And another important point was that the commission ultimately had a final say in the map. The power that city council had, so under the way the charter process is in New York City, is that the commission presents a map after a series of public hearings to city council. The charter language doesn't specifically say city council has the authority to accept it or reject it. It just says it can object to it, object to the map. And if that happens, then the commission has to go back and redraw based on kind of the input from the city council. And that will be the final plan. And so I think having that power dynamic where the commission ultimately has that final say, lend itself to more of a seamless process, and that we weren't so affected by whatever incumbent forces or political forces there may be that may wanted to have changed that. The second part was that the criteria, the redistricting criteria, was specifically laid out in the charter and by order of priority. So immediately that gave a framework, a legal framework for the commission to work with. So under the New York City Charter, the top 3 criteria to consider is the population deviation. That's number 1. At the time in the charter, it said 10% deviation, but then because of the state law that was passed in October 2021, it became 5%. So the 5% deviation did definitely present challenges, like many commissions, having that narrow population deviation where you're trying to allocate population relatively evenly, was a challenge, but that the charter was clear that had to be the number 1 priority. And then secondly, we had to provide fair and effective representation of minority groups. So that guided us. We used the Federal Voting Rights Act as our guide, as had previous commissions done. From the legal perspective, there's just there's no law on what fair and effective representation means. We try to look back at the charter documents, and there's very little guidance, but we have used the Federal Voting Rights Act, and specifically Section 2, as kind of the guidepost to making sure that we are representing protected minorities in the group. And then the third was community of interest. So community of interest is a big, important topic. New Yorkers are loud and proud, and we receive so much input. I think over 13,000 comments on what they felt their community should be. But we also had, within the charter language, the community of interest, which means established ties, communities with established ties of common interest and association, whether historical, racial, economic, ethnic, religious, or other. Is that an objective standard? By no means, but I think that it gave us a set of criteria in which we could judge public input, and also the commissioners. I want to say, one point I want to mention, and the charter also specifically says that commissioners have to be based on the ratio of commissioners, and the makeup has to be based on the number of protected minorities in New York, and they also have to represent all the boroughs. So we had that great background of commissioners who did represent protected communities of color in New York City and were representative and had deep roots in the Bronx, Staten Island, Queens, Brooklyn, Manhattan. So the commissioners themselves were an invaluable resource in addition to the public input in providing us an idea of what communities of interest look like. Because really, it is, in a sense, there's no final say on what a community of interest is. There has to be some sort of a level of qualitative analysis, I guess, to put it that way, of all the factors on what makes a community a community. So we had a lot of resources through the public input, again, and the commissioners to do that. And it was very clear that that was in the top 3 criteria. So that immediately put us on notice that we had to consider the public input. We had to take it seriously. We had to try to incorporate it as much as possible into the making of the maps. And then the final piece of it that I think what the charter did well was its emphasis on public hearings. This was a double-edged sword for us in a way, because like all the redistricting process, we had, I think, less than 9 months to come up with a map between April, when the commission was actually, sworn in, we had mandated deadlines in the charter of December 2022 because then, the maps had to be implemented for the next 2023 general elections. So we were working with less than 9 months. But at the same time, the charter mandated that, maps had to be fully distributed in the community. They had to have 30 days notice. We had to have public hearings. So trying to kind of fulfill all those requirements and having 5 public hearings in all 5 boroughs, because you got to go to all 5 boroughs, of course, and doing it twice, it did put a strain. It was a challenge timeline-wise, but I think that's the strength of the charter in requiring that public input and the community's voice should be heard, and I think that's definitely a strength that's specifically put into the charter language. So I know that the New York City Charter isn't perfect. There are a lot of, there are things that we would recommend in the future. I mean, Dr. Flateau had so many different ideas. He just was saying, we should do this, we should do that, we should rechange the entire New York City Charter language. He even talked about increasing the number of city council districts to 59. And I was like, well, that's, you want to go to referendum? You want to do that route? But I think, part of that reform process, because not every, the process is not perfect, all in all. And if I had to go back and, do it again with the commissioners who were unpaid, by the way, they're not paid at all. And they put in, 80+ hours, so thank you for your public service and that, going to all those public hearings. They were doing it all pro bono. And I think if I had to do it again, I think one important point would be we do want to have more time to think consciously about how public input is recorded on the record into the mapping sessions. We want to think about really analyzing what communities of interest look like every 10 years. So we commissioned a study with CUNY, and they had a great report that was put out on communities of interest. But that, unfortunately, because of the timing, came after the maps had come out, just because we were running on such tight timelines. But having something like that where we have some guidance from a sociological perspective, a political science perspective on what communities of interest look like, other than just, individuals or, community organizations, I think that would lend itself to some additional resources that commissioners and redistricting commissioners can use in futures, because every 10 years it changes, the demographic changes. So if I had to do it over again, that would be it. But overall, I would say we were relatively fortunate to have a well thought out charter that lend itself to a successful passing of final maps. So thank you.
Thank you.
So good afternoon, everyone. Lucia Gomez. I am the political director of the New York City Central Labor Council. We're the largest city in the country with the largest density of unions in the city of New York, but I actually played a role as the National Redistricting Advisor for Latino Justice, PRODEF. That was my 3rd round of redistricting. I had the privilege to serve with John Flateau and Esmeralda Simmons on the Unity Coalition, our first run in 2000. Not our first run, actually my first run in 2000. They had a prior in the 90s, and I had the privilege to come in as a young buck straight from college to engage and participate and learn from those minds. And then at the same time, I had the privilege of being from New Jersey and participating in the New Jersey process with an independent, supposedly an independent commission. And in 2011, I served as staff to that independent commission on the Democratic side. So I got to see firsthand the role of the independent member who happened to be the dean of the law school. I saw the 2001 independent member. And if New Jersey could do it in 2 months after receiving the census, New York had plenty of time, having gotten the census in 2001 in August. Knowing the size, right, of the state. But the reality is that, it wasn't timing, at least not from what I saw from the standpoint. Definitely a dragging of feet, an understanding of the political ramifications of not meeting those deadlines was real. I mean, the city of New York did it in the time span that they did, knowing very well that we were prepping our letters ahead of time to make sure that they held those initial, meetings. They presented the initial set of maps and that they did another round. And we were on top of it because we knew the charter deadlines. State of New York doesn't have, they seem to, have plenty of time from August when they're not in session to December, still not in session, coming into January, but that kind of blew past them. No money. So the reality is that, depending on how strong your governor is and willing to wreak havoc, put no resources into the independent commission. So you create all this brouhaha in 2014, and all the years prior to that, we were all talking about an independent commission when California was about to implement. And like always, they go first, and then we try to follow up and create something that's half-assed, which is exactly what happened with that commission. But there's a couple of elements to learn from the New York City process, right? And one reality is, aside from the fact that John Flateau was steering the ship, and he made sure that you were meeting all those because it was created on purpose to remove so much power from a commission, right? So the independent commission is required with the correct criteria, demographic, geographic, limited how much, and yet they had a lot of room to play. And they did. And we saw what they chose to do. And I did a breakdown of how many women, how many people of color, how many Latinos, how many Asians, what the demographic. I mean, we did it just to notice how, the speaker and the minority leader and the mayor took advantage of the squeaky, little ways that they can maneuver the circumstances. So it's by far perfect and by far independent. But it was as close as we were going to get in a process. And the city required a certain prioritizer criteria and creates a huge number of limitations, right? Huge number of limitations. You cannot cross counties, both counties, same counties twice. So Manhattan and Brooklyn can't be crossed on the southern border as well as in the northern border, which we currently see in Diana Ayala C in District 8 in the Bronx and Manhattan. So we had limitations based on what you cannot do. Well, I'm going to say going forward, the state needs to start creating some of those limitations. If it's not going to create nirvana, right, and we're not going to see a utopian society with an independent commission picked out of a hat of a bunch of folks that have no clue what's going on, because the majority of your elected officials have no clue what redistricting really is. The majority don't know their block-on-block boundaries of their districts. They know where they get the most of their votes in which housing project. They know which, senior center gets them the majority, but they don't know redistricting. The majority of your elected officials, of which I had an opportunity to sit down with and understand what they were looking at, do not know redistricting. You have, in the Latino community, you have like maybe 2, I would say 3 max, very, very savvy, that turned out tons of people to testify. And they've been doing this since 2000, so I know exactly who they are and all the people that turn out. It became an organizing game, and APA Voices, you out-organized everyone. But in the end, the politics and the legalities behind those, and let's say put politics in front of the legalities, right? Because they did a lot of interesting things to kind of skirt the legal. But if you don't create barriers or limitations to how creative they can get, the reality is that we will see creative map drawing. We will see academics and their friends, toy with what the political landscape in New York should and has been doing. And once we learn, because this is one of the major problems that we've seen, and I've seen the last 3 decades, once people of color finally learn the damn game, someone comes in to shake it up. Everyone wants to change it. Oh, we can't have this, and we had this. And so, yeah, it becomes a little annoying to finally see the Senate majority leader be an African-American woman of color, right? A woman from Yonkers, not even from the city. Carl Hasey to be the first African-American speaker, right? All of a sudden, change needs to happen, like pronto. because people of color are becoming the majority, both in the city and in many parts of Long Island and many parts of Westchester and many parts of upstate. So yeah, it gets a little frustrating to have to relearn a game every time. And this was one of those times. And so not one size fits all. And so we have criteria in the state constitution around block on borders. So every time I got someone telling me that we didn't meet the mapping criteria of block on border, David, I was rolling.
I hate block on border.
No one lives like that. No one organizes their communities to build the Kingsbridge Armory, redo it. No one brings additional federal funding in those ways, the way, Congresswoman Nydia Velasquez did in District 12 and didn't want to damn lose her waterfront from Sunset Park. Sure. Some of us who have been trying to fight for equality on the ground with resources, with proper housing arrangements, with proper, real projects in our neighborhoods, yeah, we saw it a little differently. And for those that don't know the political game on the ground on an E-Day, turnout is abysmal. So don't be shocked that people who testify on the technical, political, and legal aspect of redistricting are going to be limited to those that are being schooled by those that need them to testify. So I don't want to hear all the, there's very rare to hear the Ridgewood zip code talk about our insurance rates are going to go up if she's teamed up with, Bushwick. That we always seen in a couple of hearings. And let's not get this twisted. Congressional redistricting has not been drawn from the legislature since I've been drawing in 2000. The legislature did not draw congressional seats. They left it up to the courts. In 2010, they left it up to the courts because the Republicans and the Democrats don't see eye to eye on their own seats, because in the past they would just pass, I keep the Assembly, you keep the Senate, you understand? So they would have their deals. They never came to a consensus on congressional. So I enjoyed going to Steuben County. I enjoyed hearing another judge have no clue what he was listening to. Let alone everyone coming with their flashy, all the attorneys that I saw that I had never seen anywhere near a redistricting hearing from both sides. Because they're all in the back figuring things out for when everyone else fails. For when all of us are drawing our single map and presenting that one map, not taking into account all the other people that live in the rest of the state, right? So there's so many interests at play. You can either get your existing legislature to agree to box themselves out and remove themselves from the equation. And the majority, that starts with 2 people. Let's not get this twisted. They need all their colleagues to vote. But the reality is that you start with 2 and they'll get their colleagues who elect them to do what they need to do. But if you don't do that, at a minimum, an independent member, perhaps, and the way they do it in New Jersey is that Republicans and Democrats put a name in a hat, and the one that is common to both of them gets picked. So you usually get the dean of the law school or the head of the political science department over at Rutgers, right? Someone, at one point, they got some random guy who wasn't even registered to vote. That was in 2000, and he made a huge splash. And the reality is that an 86% Democratic vote district would have been flawed in New Jersey, because that is packing of Dem votes. And in 2001, when one of those cases came up, it was horrible. So yeah, I would see a waste, complete waste of, letting all dense New York take the blow. And yet when we're dealing with budgetary issues in Albany, we get the short end of the stick because we have too much, power to carry on to Albany. So it is a little bit of a conflict. And to talk about partisan, being equal, all things equal, but when you go to Albany, all things are not equal when funding is dished out, when those numbers and those districts and bringing home, the types of needs that we have is not balanced out. So, I don't like to be all balanced mindset. So the last thing I would say is, aside from the block on border dynamics at the constitution level, creating the restrictions, you got to bring up those techies more out from the shadows to explain to people why X, Y, and Z is not doable, or why X, Y, and Z has limitations. Because if I don't know how many Senate damn seats this legislature is going to agree upon, there's a mathematical computation, which I am not going to, Todd Britbar is the mastermind of that, but there's a mathematical computation that allows them to go up or to go down. And so when we draw as advocates or communities, you don't know if you're drawing for 62 seats, 63 seats, shit, they can go back down to 59, or they can go back up 65, whatever. The point is that we need to know from the beginning what we're starting with. And that was always a moving target. So I would say the Constitution, aside from creating an ideal scenario the way it was laid out by so many, I would say create constraints by the map drawers, by the academics, and by the elected themselves, because that was the only way that we were able to get a city council that is representative of the people that live there. So thank you.
Thank you. Nobody move. Thank you. Round of applause for this great panel. Thank you. We're a few minutes behind schedule, but everybody sit tight. We're here about 10 more minutes. We're going to hear from, Jeff's going to introduce our final speaker and then offer his closing remarks. Thank you to this panel, but stick around for our final couple of remarks here, folks, please.
Did a report, 2020 redistricting cycle. This is where we draw the line. We have extra copies here. So if anyone would like some, please come to this table. Thanks so much.
Okay, our last presentation will be from Bridget Bergen from WNYC Radio and The Gothamist. As a journalist, her reflections on both the recent process and also on what the panelists here had to say earlier this morning.
Thank you, Jeff. Thank you all for sticking it out. I will keep my comments brief, in part because most of the panelists who you heard from today are the people that I call when I am doing my stories about all of this. And I will say, in the past few years, we've done a lot of stories about redistricting because we have covered the ups and downs of all the lawsuits, the way the maps have changed. And part of the reason we do it, you know, I am the media that was referred to for better or for worse in some of the comments today. But the reason that we talk about these issues and try to take these very complicated legal questions and turn them into stories that are meaningful for our readers and our listeners is because we know that these are more than just conversations about lines and boundaries and these very important maps, communities of interest, all the interwoven socioeconomic indicators. But ultimately, we're having conversations about power. Who has it, who keeps it, how it changes. At the most local level, that's, you know, determining what communities get a say in how our money is spent, who gets listened to when there's a problem. So when I think about where we were at this time 2 years ago, we were preparing for not one, but two summer primaries, statewide and assembly races in June, and those congressional and state senate races in August. We were wrapping our minds around this new set of congressional district lines drawn by Professor Service and his team that, as he noted, did not take into account where incumbents at the time lived. And you can ask either former Representative Maloney's about that. And since we've seen more lawsuits, new lines at the congressional, state, and local levels. And as we think about what needs to change for the 2030 cycle, I can tell you one of the things that I'm trying to come back to is how do I tell these stories that are very process-driven without losing sight of voters and the people and neighborhoods and communities that are impacted by which side of the street the boundary ends up on and who ultimately represents them and what happens by which party that controls the House. So what I've been doing today is I've been listening to everyone, is thinking about what are some of the possible stories going forward. And if we had more time and I had a microphone, I would, you know, ask to pass it around and ask you all what you think some of the storylines are going forward. But you can find me on X or Twitter, or you can email me or reach out in any way, because one of the things that we really want to know is, you know, we want to hear from you about the things that are happening sooner rather than later. So some of the things that I've taken away from our conversation this morning, of certainly Professor Service's important observation that all line drawing should focus on voters and not on politicians. The very interesting observation that the Upper East Side and Upper West Side have differences, but those differences are less important than Uptown, Midtown, and Downtown. debatable. Will there be enough funding or resources needed to do this redistricting process correctly going forward? And can the state revamp it in time? And who are the leaders that are going to push that forward? What should the membership of a new commission look like? Clearly, a lot of people raised the concern about the even number of members, and is that destined to fail? As former Representative John Faso suggested, will the state legislatures take the recent round of litigation as a warning about how far to go in the future? You know, we'll see. Who are some of the community leaders that are fighting for their neighbors to represent them? And how can we make sure that we tell their stories early and soon? Is there a narrative out there that could be compelling to follow over time? That's the type of stuff, certainly where I work, in public radio and public media, those are stories that can be very compelling. And if we can start earlier and then have something to tell over time, I think that can be really engaging for an audience and maybe give us an opportunity to demystify some of what's happening and take some of the jargon out of what can be really complicated issues. I loved Lucia's comment about getting the techies out of the shadows, because I think that there is something going on there that people need to understand how this process is done. And we're in the position of trying to help them do that. So also FOIL doesn't apply to the IRC. Okay. So I'm grateful so much to have been here to listen to the different perspectives for all of you who've worked so long on these issues. I think the one thing that we can all agree on is there's a lot of work ahead. And from my perspective, that means there are a lot of important stories to tell. So I hope you will reach out to me and my colleagues with your pitches, your ideas, the characters who you think should be covered. Many of you have done that in the past, and please keep doing that. Please keep taking my phone calls when I call you at random times, because I'm on deadline and I need to understand something. I really value what you all do. I know this work is so important, but it's not simple. And so with that, I'd say here's to 2030. I'll give it back to Jeff.
Well, anyone know the reason why the IRC is not subject to FOIA laws? Answer is because the IRC has been deemed to be part of the legislature, so much for independent. The commission is funded through the legislature, and the staff members work through the legislative payroll. Just venturing an answer. Well, thank you all for spending 3 hours with us. Again, just to remind you, to those of you who are attorneys seeking CLE, as you leave the building, please sign out to get your CLE credit. There is still food at both sides of the table, so lunch is now served. Reversing gears here. And we'll have further programming later this year. We're going to look at the new State Voting Rights Act and just point out that beginning in September of this year, all election laws in New York City and in many parts of New York State will be subject to a so-called pre-clearance process, very similar to what the federal Section 5 Voting Rights Act required. So there's a lot going on in this area.